All right, we're back. We were talking about immunity, use immunity, and absolute immunity. And I want to emphasize to you that the way this works in the real world is that number one, the prosecutor is the only one that can offer immunity. So if the defense has a witness that they want to put on the stand and they want to offer that person immunity, the prosecutor is the one that has to do it. So oftentimes you'll get these very heated arguments between the defense attorney and the prosecutor because the defense attorney wants to put this person on the stand, but the person won't take the stand unless they're offered immunity. Prosecutor has that discretion. Oftentimes the prosecutor is not going to agree to it for a variety of reasons. Um, and so you have this ongoing battle between the two attorneys. Um, so it's the prosecutor that has the power to offer immunity. The court must agree to it. In, the law in California says that the prosecutor, if they're going to offer immunity, has to do it in writing. So you're going to present. There's a written motion, a specific rules that you have to follow, and you generate this motion and you present it to the court prior to trial. And you say, Judge, this is our intent. We have Mr. Jones. We want them to testify. Um, for instance, in domestic violence, this is very common because the victim at times will lie to law enforcement. And so now you want to put the victim on the stand so that she can testify, or he can testify, depending on who the victim is, that yes, they're a victim of domestic violence. But they did at one point lie to law enforcement. So the prosecutor will have a written motion that they present to the court saying, we're offering immunity. It's going to be use immunity usually. And so that the victim can take the stand and testify as to why they're a victim. That's very common in domestic violence cases. So you'll have the prosecutor submit a written motion, and then the court has to agree to it, and then you go on the record, and the prosecutor explains what their intent is, and then the defense can object, put their objections on the record, and then the court will agree or disagree with the prosecutor and allow the witness to testify with immunity. Um, um, what happens when a witness asserts their Fifth Amendment right to remain silent? So what you see on TV is somebody will stand up and say, "I, assert my Fifth Amendment right to remain silent," and then everybody goes, "Ooh," and then the person walks away or walks off the witness stand and they go home. In the real world, that's not how it works. In the real world, if if you know that you have a witness and that witness has already told you, "I'm not testifying, I'm going to assert my Fifth Amendment rights," oftentimes they'll have an attorney, and you've talked to their attorney, and so you know in advance that this person is not going to be a cooperative witness. You still call that person to the stand, so that could be the defense attorney or the prosecutor. But before you do that, you're going to inform the court. You're going to say, "I'm calling Miss Jones, and by the way, Your Honor, I believe she's going to assert her Fifth Amendment rights." And so what the court will do is the court will call that witness to the stand outside the presence of the jury, put him on the stand and ask him, "Do you intend to take your Fifth Amendment right?" And if they say yes, and that what the court will do at that time is tell the attorney, whether it's the defense attorney or prosecutor, whoever's called this witness, ask your questions. So the court evaluates your assertion of your Fifth Amendment right to remain silent question by question. It's not one blanket, "I'm taking the fifth, you can't touch me, I'm walking away." That's not how it works in the real world. On TV, it's very dramatic. It's like, it's that moment when everybody goes, "Oh my gosh." But in the real world, you start asking questions. So you generally have a list of written questions. You ask the question, the person asserts their Fifth Amendment right, the judge evaluates the question, and the judge will tell the witness, um, you're going to have to answer that question, or the court's going to make some comment about that they agree that this could incriminate them, and then ask the attorney to move on with the next question. And so, as the attorney asks the questions, you go question by question, and you, as the attorney, you're marking off which ones you're allowed to ask and which ones you are not. Then, when that process is done, and that may take a day or 2 days, it depends on how many questions the prosecutor has or the defense attorney, the jury's called back into the courtroom. And then that attorney will ask only those questions that the court has identified as acceptable questions that they determine are not self-incriminating. So it's a very long and tedious process, and clearly not what happens on television. All right, so when the defendant does take the stand, so when they waive their Fifth Amendment right and they decide that they're going to take the stand, there are rules that follow, and the most important rule is that once they take the stand, they've waived that right. So they are at that point an open book. The way it works in the real world is that the issue of the defendant taking the stand is not going to come about until the prosecutor has finished their case in chief. What that means is that the prosecutor has to prove beyond a reasonable doubt that a crime was committed and that this person's the one that committed the crime. And so the prosecutor will put on their witnesses to establish the crime and to establish that this person's the one that committed that crime. Once they've done that, once they've presented all their evidence, they will tell the judge, Your Honor, the people rest. And what that means is they're done. There is no general rule is that you can't go back and clean up. Sometimes a judge will let you go back if there's maybe a witness that you realize that you made a mistake and that you need to ask them additional questions. But most of the time, once you say you've rested, then the defense makes a motion right then before they put any witnesses on, before anything happens. They will make a motion to dismiss the case. And what they're saying is, Judge, even if you believe everything that the prosecutor presented, it's still not enough to convict my client. And so the judge will take that motion and make a ruling on each charge. So if there's 10 charges, the judge will make a ruling on it as to each of the 10 charges. And if the court believes that the prosecutor has not met their burden on one or more of the charges, the court at that time will dismiss those charges. That means you can't take it back, you're done, you screwed up, or the evidence just wasn't there. And then whatever charges are left, now you move forward. And now the defense will present their case. Usually, most defense attorneys, as a strategy, will not put their client on the stand until the very end. So let's say a defense attorney has 4 witnesses. They are going to put all 4 witnesses on the stand, have them testified, and then the last witness to go on the stand will be the defendant. Once a defendant takes the stand, they've already been admonished that they're waiving their right to remain silent. They'll have been told that once they take the stand, they're going to have to answer questions. So once they take the stand, the first thing that's going to happen is the defense attorney is going to be the first one to ask them questions. And usually the defense attorney will have a series of questions to ask, and they'll ask that pointed question, did you commit this crime? And then that gives the defendant an opportunity to deny their participation in the crime or explain why they were present or participated in whatever aspect of the crime they participated in. And then once the defense attorney finishes asking questions, then the prosecutor can ask questions. And the prosecutor's allowed to ask any question that's relevant to the trial, and the defendant has to answer. So the defendant cannot pick and choose which questions to answer. So for instance, if this is a case, let's say that this is a robbery, but the defendant has a history of drug use. Well, the prosecutor can go into all those questions about why you use drugs, how often you use drugs, because it's relevant to show that whether or not the defendant was on drugs at the time of the crime, and now whether they can recall what happened if they were high. So the prosecutor is going to ask them, were you high at the time? That, were you on methamphetamine? Were you on cocaine? Were you on heroin? Were you smoking marijuana when you committed this crime? And the relevance for the prosecutor is your your recollection of what happened is going to be um, be affected by the amount of drug use. So not only can they ask, do you use drugs, but they can ask how often you use drugs. Did you use drugs with the other defendants? When was the last time you used drugs prior to this crime? And the prosecutor could also be asking those questions to show motive, like why would you commit a robbery? You're committing robberies because you're a meth addict. So it really exposes the defendant to a wide variety of questions. And the rule is you have to answer them. So let me go through the list here. So the prosecutor can't call the defendant to the stand, but once the defendant takes the stand, they can ask questions. The decision to take the stand is solely on the defendant. The defense attorney will, as part of their job, advise the defendant whether they should or should not take the stand. Most of the time they say no. Sometimes, based on the facts, they will encourage their client to take the stand. It's a strategy, and I've seen defendants take the stand and do a really good job. And so, it does work. So, and then the last one is the defendant must answer all the questions. Okay, so there's a list of, these are all the physical pieces of physical evidence that are all outside the protection of the Fifth Amendment. So fingerprints, breath tests, blood tests, DNA samples, body fluids, hair samples, writing exemplars or writing sample. So if they, let's say they wrote threatening letters, there's trained professionals who have them write, they'll have them write on paper, and then they'll compare the style of writing, the way they formed their letters with the relevant letters that were part of the trial, and then they'll give an opinion at trial as to whether or not the writing that's in question at trial is this, was done by the defendant. So voice samples, lineups, photo lineups, cavity searches, all that is physical evidence, and it all comes in. It's not protected under the Fifth Amendment. So for medical procedures, if you want to if you want to remove any kind of body part, we've talked about this before, so I'm going to go over it real quick. Is that if you are going to penetrate or go into the bodies, if you're going to intrude into the body of a defendant, you're going to have to get a search warrant or consent, and it's going to have to be done by trained medical personnel. And the court is, if you ask for a warrant, you're going to have to show that you're not putting the defendant at any kind of serious risk of injury in order to, for instance, to remove a bullet. Or blood samples are pretty straightforward. Those are not a big deal other than having to get a warrant. And courts will sign off on a warrant if it's appropriate on a routine basis. But there have been cases where prosecutors or police officers want to remove a bullet from somebody that may be lodged near the spine. And the courts have said, no, you're not going to go in because you run the risk of paralyzing the defendant. All right, so medical procedures have to be minimally intrusive. They have to be completed by a medically recognized individual, trained individual, and in a medically recognized manner. Let's see. So, like I said, search warrants may be required anytime it's intrusive. A buccal swab of the inside of your cheek is considered not to be intrusive. Blood draws are considered intrusive. And then we've already talked about DUI blood draws. What else? And that's it. Okay. So it took a little bit longer than I thought. All right. So prepare an outline. Do it in a bullet point form. And then I'll have an assignment in Canvas, and you can just upload it to the assignment sheet. All right, take care, be safe, and I hope that you're able to get out of the house whenever possible and visit other people. All right, take care.